at Winckworth. So as I say, my name is Kevin McManamon. I'm a solicitor and partner in the education team at Winckworth Sherwood, and in particular, I form part of the SEND law team, which does also incorporate mental capacity in relation to, more specifically, personal welfare. Just a little bit about me. That's a little bit about the firm and our team, but I'm not going to dwell on that too long because you're not really interested in hearing about who I am or who we are. You're more interested, hopefully, in the topics we're going to discuss today. So let's have a look at what we're going to discuss. I thought it was helpful just to give everyone an agenda so you know where we're going on things. So the first part of today's webinar, talk, workshop, whatever we want to describe it, we'll go through the guiding principles and key issues of mental capacity law. Now that can be a little dry, I'm afraid, so I do warn everyone in advance. I will try and explain it in as simple terms as I can. I've set out the actual legislation from sections 1 through to sections 4 of the Mental Capacity Act. I think that's really quite important, and we'll talk through those in quite some detail. But hopefully I can give you some anecdotes as well in terms of previous cases that I've acted on and issues that have arisen and how we've dealt with them. So we'll look at the principles first, because I think we can't really delve into what the court of protection does and so forth without looking at the principles underpinning that and how the court of protection looks at things. We'll look at one-off decisions. Because the court of protection, that's what it prefers to do. It prefers to make one-off decisions. We'll then look at the issue of deputyships, and we'll look at lasting powers of attorney, and we'll look at the differences between those two. And then I will finish off by talking a little bit about capacity in relation to the SEND Tribunal, because I tend to find that that's an issue that parents and young people in particular want to know about, because there is quite unique specifics in relation to capacity and the SEND Tribunal. So that's what we're going to be looking at and going through today. And as I said, there should be more than enough time for anyone to ask questions at the end. In terms of asking questions, that part of this session won't be recorded, so please feel free to ask whatever questions you've got. Please feel free to anonymise any details that you want to anonymise. That's not a problem at all. Right, so mental capacity law. Key sources, so back to basics. Starting point is the European Convention on Human Rights and Fundamental Freedoms. That's really key. That's your backbone international law underpinning. I say international, it's now actually incorporated into domestic law via the Human Rights Act. Key piece of legislation in England and Wales is the Mental Capacity Act, and that's what we'll be focusing on. Other things that you need to be aware of, and I've put in here the lasting power of attorney regulations. That's very specific to lasting power of attorney. If you're not looking at lasting power of attorney, you don't really need to worry about that. We've got the court of protection rules and the code of practice, and I'll be talking a little bit about the code of practice because what that does is it fleshes out certain parts of the Mental Capacity Act, to be honest with you. So let's get into it. Key piece of legislation, as I said, is the Mental Capacity Act 2005. And section 1 of that sets out key principles, and I'll talk through each of these with you. But these principles go all the way through the Act and go through everything that we should be thinking about when we're looking at mental capacity. So I've put these principles first because I think it's important to always bear in mind these principles when we're looking at other things, such as how do we determine if a person has capacity and all of those things. So starting point, a person is assumed to have capacity, okay? So the starting point is we assume every individual has capacity. Second principle, an individual is not to be treated as unable to make a decision unless all practical steps to help them to do so have been taken without success. Now, I've often referred to this as effectively a duty to make reasonable adjustments. I know it's not coached in those terms, but I've said that previously. I've said that previously in front of a number of very eminent lawyers, and nobody's necessarily disagreed with me. So whilst the law doesn't put it in those terms, in terms of the way you think about things, you can certainly think of it in that way. Next principle. we're all entitled to make unwise decisions. Simply because the decision is unwise, it doesn't mean that a person can't make the decision. Quite often, people on a daily basis make unwise decisions because of the principle of autonomy. The law says we're entitled to do that. So simply because the decision's unwise doesn't mean that the person can't make that decision, or is unable to make that decision, I should say. Fourth principle, really, really key. Any act, any decision made on behalf of a person who lacks capacity, and when I'm talking about lacking capacity, I'll go into that in more detail, but who is unable to make any particular decision, any decision on their behalf must be made in that person's best interest. And we'll look at best interests in a lot more detail, but that is key, and that runs throughout the Act, best interests. And finally, when we're looking at making a decision on behalf of a person who is unable to make that decision themselves and therefore lacks capacity in relation to that decision, we should always be thinking about the least restrictive option. And what I mean by that is, for example, if one needs to make a decision that an individual's liberty needs to be restricted because it's actually in their best interest, because they're likely to harm themselves were that not to happen, then if there's an option of having an individual sit with that person, or you lock them in a room, well, what's less restrictive option? We're clearly having a person sit with them. So, and that's quite an extreme example I've given there, but it's an example that hopefully helps you to understand what we're talking about when we're looking at least restrictive options. But we use least restrictive options really quite frequently in the Court of Protection when we're looking at deprivation of liberty and so forth. So they're your key principles. So we've looked at the first principle in terms of there's an assumption in favour of capacity. So in order for the Mental Capacity Act to kick in, as it were, and all of those other principles to apply, they only do so if a person lacks capacity. So when will an individual lack capacity? And the Act's clear on this. It's where a person is unable to make a particular decision for themselves because of an impairment of or a disturbance in the functioning of the mind or brain. Now, that wording is taken specifically from the Act. I appreciate it's not particularly pleasant wording. I appreciate if we were wording that today, we would probably word it differently, but the Act is some 20 years old or so now. What I would say is that does have quite a large scope, though. So an impairment of or a disturbance in the functioning of the mind or brain. Generally, we'll need some form of medical evidence to establish that. It's not necessarily a particularly high threshold, in my experience, but generally we'll need some form of medical evidence. Simply because an individual has a diagnosis of a particular type, though, doesn't necessarily mean that that's it. They lack capacity, and I'll come on to it, or they're not unable to make a decision, I should say, and I'll come on to that. It doesn't matter if the impairment or disturbance is permanent or temporary. And that's because, and we'll look at this in more detail, but decision making and therefore capacity in relation to decisions is time specific and decision specific. So you can have what's called the principle of fluctuating capacity, which means that an individual at certain times may have capacity, but other times may not have capacity. An example of that, actually, I've seen is where an individual had a UTI infection, and actually that UTI infection meant that they were unable to make a range of various decisions. However, once that UTI infection was treated and so forth, the individual was able to make specific decisions. So that's why we've got here, it doesn't matter whether it's temporary or permanent. A lack of capacity cannot be established merely because of a person's age, And again, this is to do with subjective assumptions. So you can't simply assume because of a person's age they lack capacity, or simply because they have a condition or an appearance of their behaviour where an individual may make unjustified assumptions. So we can't just assume because there's a particular diagnosis, then they automatically lack capacity to make a particular decision. And the last point I've made here is just an evidential one, and that is the burden of proof is balance of probabilities. So more likely than not, if we're looking at it in percentage terms, over 50%, if that makes sense. And that's the standard civil burden of proof. So it's not necessarily controversial that that's what it is in the Mental Capacity Act. So we've talked about that's when an individual lacks capacity, if they're unable to make a decision because of an impairment of or disturbance in the function of the mind or brain. Now, what we need to do is go and delve into this a little deeper in terms of, well, how do we know when a person's unable to make a decision? Well, how do we determine that? And hopefully, if by magic, the next slide should tell us that, and that's then looking at section 3 of the Mental Capacity Act. Now, a person is unable to make a decision for themselves if they are unable to, and it can be any of these. Understand the relevant information to the decision. And what I would say to that is, as I said, decisions are, and capacity is decision specific. So each decision, there will be different relevant information that an individual needs to be able to understand. Whether that be decisions in terms of residence, where one should live, social care, education, contact with others, social media, and internet access, all of those require different pieces of information for an individual to understand. So that's why you can have a scenario where an individual is able to make decisions in relation to specific things, but not others. And an example I often give, and it's an extreme one, in terms of whether an individual has capacity to, in relation to their diet. Well, the relevant information there is clearly going to include understanding at least concepts and the information around healthy eating and nutrition and all of those things. Now, an individual may lack capacity in relation to deciding on their diet. However, they may well have capacity to decide between two options, as it were, let's say spaghetti hoops or baked beans. So if they've got capacity to decide between those two options, then we allow them to decide between those two options. So that's understanding the relevant information. The individual then must be able to retain the information long enough to use and weigh it up and then communicate their decision. So in order for me to have capacity, I must be able to understand the relevant information, retain it long enough to then weigh it up and then communicate my decision. If I can't do any of those aspects, then I am unable to make that decision, and therefore I lack capacity in relation to that decision on the basis that's because of an impairment or a disturbance of the functioning of mind or brain, which we've looked at previously. In terms of communicating a decision, that decision does not have to be communicated orally. Can be orally, can be using sign language, can be used any other means, assistive technology. An individual may have a condition that means that they're only able to communicate through assistive technology and eye blinking and so forth. If they're able to do that and communicate their decision that way, well, they're still communicating their decision. So as long as they fulfill the rest, then that they will have capacity. The other thing that we need to be aware of is that simply because information is provided in a certain way doesn't mean that a person should be regarded as lacking capacity. Effectively, if information can be provided to an individual in a simpler format, then and they're able to understand it in that simpler format, well, as long as they're able to understand the relevant information, they're able to understand the relevant information. So all appropriate steps need to be taken when looking at an individual's ability to make decisions in relation to a particular issue, to really ensure that all practical steps, as we talked about in terms of the guiding principles previously, have been taken. So that's a key element there. That's the purpose of that. Now, this is very interesting, actually. The fact that a person is able to retain the information relevant to the decision for a short period only does not prevent them from being regarded as able to make the decision. As I said previously, they must be able to understand all relevant information and retain it long enough to weigh it up and then make a decision. And then communicate their decision. So if, for example, you've got an individual and you can sit down and you explain all the relevant information to them and they're able to understand all that information, and they can retain that information long enough to weigh it up, use it and weigh it up, make their decision and then communicate it, well, they've got capacity at that moment in time. If tomorrow you have to sit down and you have to explain it again, well, we're not talking about tomorrow. We're talking about if they can make the decision today, is whether or not they can retain it long enough to be able to make that decision and then communicate it. And that can be more relevant in older individuals where potentially you're looking at dementia and so forth. Now, as I said previously, in terms of relevant information to a decision, that is decision specific. It's always got to include the reasonably foreseeable consequences of either deciding one way or another or failing to make a decision at all. But in terms of what that information is, it is different depending on the decision being made. So, for example, in relation to sexual relations, information that an individual is required to be able to understand and so forth is relatively low when you look at actually whether an individual's got capacity to make decisions as to who they should have contact with, for example. I just give that as an example because what I really do want to hammer home is the importance of realization that it's not simply a person has capacity or they don't. It is time specific and it is decision specific. Now, we've looked at determining when a person's unable to make a particular decision, and if they're unable to make a particular decision, then they lack capacity to make that decision. Well, what then happens? Well, where an individual lacks capacity to make a decision, then any decision made on that person's behalf must be made in that person's best interests. And at the very beginning, hopefully you'll recall in terms of the guiding principles for the Act, I mentioned best interests, and it's set out here in terms of Section 4 of the Mental Capacity Act. Really, really important concept. I'll go on in a moment to look and see what the Code of Practice tells us about this, but the Code of Practice really, I think, just fleshes out what's said here. And what is said here is that as far as reasonably practical, we must permit and encourage the person to participate or improve their ability to participate as fully as possible in the decision making. So even if they lack capacity, that individual, as far as can be reasonably done, must be involved in the decisions made about them. And that involves a whole host of things. So looking at what their previous wishes and feelings were. I've said here in particular if there's any written statements made by them when they had capacity. I mean, that's a dream situation from a lawyer's point of view because that's contemporaneous evidence. Quite often, we're not lucky enough to have that. So it'll be evidence from potentially family members quite often as to what that person, when they had capacity, what they enjoyed, what they didn't enjoy, what religious beliefs they had, um, or non-religious beliefs they had, for example, whether, let's say, they were a vegetarian previously, because if they were vegetarian previously, then when you're looking at best interests and taking into account what their wishes and feelings would have been and so forth, and that may well be a very relevant consideration in terms of making decisions about their diet, for example. So, as in, yeah, values and so forth are very important. And in terms of participation, a number of cases I've been instructed on was via the official solicitor acting for what we call P. The P is the protected party, and effectively that's the individual that lacks capacity. And the official solicitor would always want me to go and visit that individual wherever they were residing and see if I was able to ascertain any wishes and feelings from them whatsoever. And they'd expect me to make a note, and then they'd expect me to put that into a witness statement setting out what that individual's wishes and feelings were. And quite often, you will have an individual that will express to you very, very clear wishes and feelings. Sometimes, depending on the individual's condition and so forth, they're not able to do that. But sometimes they are. Now, I'm going to move on to the next slide before I give you the next anecdote, because I think it'll be helpful to look at see what the Code of Practice says. Right. So, Chapter 5 of the Code of Practice delves into a bit more detail about best interests and so forth. So, do whatever is possible to permit and encourage the person to take part or improve their ability to take part in making a decision. And so we look at their past behaviours and so forth. We look at religious, cultural, moral, political, all of those views. Now, a case that comes to mind from my point of view was when I was acting for a lady who had, unfortunately, quite an aggressive form of dementia. I became involved when she was temporarily in a care home and her husband wanted her to move back home with him. The complication in that case was the husband had formed a new relationship and had moved his new partner into the home, and he wanted into the marital home, and he wanted his wife to return and live with him and his new partner. So, when looking at wishes and feelings, I wanted to explore what my client, the protected party P, what her wishes and feelings would have been in relation to that. And in fairness to husband, he was quite clear. He said if she had capacity and she knew that I'd moved somebody else in, she'd probably do very unpleasant things to me, was the way he put it, but probably not so eloquently, shall we say, but you get the gist. Now, that was very helpful then in establishing, well, if that's likely to be her wishes and feelings, and that then needs to feed into actually, is it in her best interest to return to the marital home in that type of environment? So it's an example that doesn't really happen very often. I've only come across it once, but it gives you an idea of what we're looking at in terms of looking at wishes and feelings. Now, what I would say is, whilst wishes and feelings are really, really important, they are not the veto, as it were. One can make a best interest decision where we've looked at wishes and feelings and we've taken into account wishes and feelings, and even having regard to those wishes and feelings, it's not in that person's best interests for a decision to be made in line with those wishes and feelings. And again, I've had a case where, again, we had a gentleman in a care home at that point in time. He wanted to move home back with his wife. His wife was in a position where she loved him very much, absolutely, but she was just not in a position to care for him, and it wouldn't have been safe for him to move back. And he was quite clear, and he was quite eloquent with me. That is what he wanted to do. And he was quite clear that he wanted to speak to the judge about it. So we brought him to court and we gave him the opportunity, sitting down with me and the judge, to go through and for him to explain exactly what he wanted. And we did that. But ultimately, the court found, and ultimately, me acting on his behalf, had to be quite clear that yes, I am putting forward his wishes and feelings, and it is fundamentally important that the court is aware of his wishes and best wishes and feelings. But ultimately, it's not in his best interests to do what he wants to do. So wishes and feelings really, really important. Should always be considered, but then not a veto. And I think that's important to point out. So, in practice, mental capacity is a really difficult concept. Okay, so the law around it, as I've run through with you, appears relatively simple. It's just the application that can be really quite difficult. They're often very emotive situations, and I would say some of the most emotive cases, some of the most emotionally draining cases I've been involved in have all been in the court of protection and have all been around mental capacity. Because we're potentially making some really serious decisions about individuals. But it is really important. The work of the court of protection is really important. Now, before I go on to talk about the court of protection and what it can do and so forth in its jurisdiction, it's important that I just point out the court has no power to exercise any of its jurisdiction, so it just does not have power to make orders in relation to those under 16. Okay, those under 16, the concept of parental responsibility is still relevant. And ultimately, if there is a dispute in relation to a young person under the age of 16, then that wouldn't go to the court of protection. That would either go to the family court or in specific circumstances, and we see them fortunately very infrequently, but for example, where we've got cases where decisions need to be made in terms of withdrawing life-sustaining treatment from babies and so forth, that they go to what's called the inherent jurisdiction of the High Court. The other thing to be aware of, though, is I've popped it down here, is Gillick competence. Okay, it's a relatively old case now, actually, but it was a case involving a 15-year-old young lady who went to her GP and wanted to obtain advice and thereafter contraception. And I believe in that case it was contraceptive pill. Her mother took that to what was then the House of Lords, what we now call the Supreme Court. And ultimately, what the court said is, well, if this 15-year-old is able to effectively, and the case was before the Mental Capacity Act, but effectively it was this very similar test. If she's able to understand all the relevant information, retain it, weigh it up, and communicate a decision, if she's able to do all of those things, then she has what's called Gillick competence. And in those circumstances, she has capacity to make those decisions. So bear in mind, under 16s can have capacity to make decisions in certain circumstances. So I just flag that. Now, the other thing to be aware, there is a difference, and there does appear to be a difference between agreeing to medication and so forth and refusing medication. In terms of those 16 and under, the court is slightly more protectionist in relation to individuals refusing life-saving treatment. So I flagged that, not that it's necessarily relevant for this talk, but just so you're aware of it. So, the Court of Protection, what is it? Well, it's the forum to address a whole wide range of issues or disputes which can't be resolved elsewhere in relation to individuals who lack capacity. As I've mentioned previously, it doesn't have jurisdiction in relation to those under the age of 16. Furthermore, it doesn't have jurisdiction in relation to any individual who has capacity. So bear in mind, the Mental Capacity Act assumes everyone to have capacity. The Court of Protection only has jurisdiction to those over the age of 16 where it can be shown that they lack capacity to make a particular decision. Now, what can it do? It can make declarations in relation to individuals' capacity to make specific decisions, as well as the lawfulness of any act to be done in relation to that person. So effectively, the court will step into the shoes of, and I refer to it again as P, but P is the protected party in the Court of Protection. So it can make declarations as to whether an individual lacks capacity. It can make declarations as to whether a particular act or acts are lawful and in that individual's best interests. And when I say lawful, they're lawful where it's determined that it's in the individual's best interests. And we'll look at this in a bit more detail later, but it can appoint deputies in relation to personal welfare and property and affairs. And it also consider the lawfulness of any deprivation of liberty safeguards and authorise a deprivation of liberty. I haven't gone into deprivation of liberty really within this session, but if people do want to discuss it in the Q&A, I'm more than happy to. And depending on where we are with time, it may well be that actually I have time to discuss it at the end before we have the Q&A. So, main orders of the Court of Protection. The first, and I touched on it, is declarations. So the court can make a declaration as to whether a person lacks capacity to make a specific decision. Now, you can ask me, what's the difference between A and B? The difference between A and B is A relates to a specific decision, B relates to more than one decision. That's the only real difference in terms of A and B, in terms of section 1A, subsection 1A and subsection 1B. It can also make declarations as to the lawfulness of an act to be done or not to be done, actually, in terms of an omission as well. And I've said this here, acts also include omissions. So the first thing it can do is it can make declarations. And I'll come on slightly later as to why that's so important. It's also got power to make decisions and appoint deputies. So it can make declarations, but it can also make orders and make decisions on behalf of an individual who lacks capacity, stepping into their shoes. And I'll talk a bit more about that in slightly more detail a bit later. Now, it can make decisions and appoint deputies in general in relation to personal welfare and property and affairs, and they're two quite distinct things. And when we talk about deputies and LPAs a bit later, I'll explain the difference between personal welfare and between property and affairs. Actually, having just scanned through it, I think that's all probably you need to know on this slide. Any additional information, I think we'll talk about a little bit later on. So, let's look at one-off decisions. This is the preferred method from the court. It's got the power to make one-off decisions in relation to any aspect of P's personal welfare and or property and affairs. And the court prefers to do that. It prefers to look at matters on a one-off basis if it can. Now, in terms of why a matter would escalate to the Court of Protection, let's look at that. So where an individual lacks capacity, in relation to a specific decision and there's no LPA or deputyship in place, then the Act tells us any decision made by or on behalf of that individual must be done in their best interest. We know that. The question is, well, who makes that decision? Well, in the first instance, it's all relevant stakeholders. So that will depend on what type of decision is being made, or what the decision needed to be made is, I should say. So if we're talking about medical treatment, for example, that when we're looking at relevant stakeholders, that's likely to be the close family members of the individual. And it's also likely to be the medical treating staff. Now, if all sit down and look at best interests, look at wishes and feelings and all of those things, look at least restrictive options, look at all of those things together, and actually all come to a decision that this course of action is in P's best interests. I mean, I would certainly advise that that's properly documented. But if it is, then that decision then can be made. And there is no need to necessarily go off to the Court of Protection. It is only if one, and it only needs to be one of those relevant stakeholders disagrees, then the matter should be referred on to the Court of Protection for the court to make it, to step into the shoes of that protected party and make a decision. Again, when we're looking at things like accommodation or where the protected party should live, health may not necessarily be involved in that. The family members will inevitably be, but the local authority may well be as well. And again, the same thing should happen in terms of everyone sits down, they have what's called a BIM, which is a best interest meeting. All of the available options should be looked at. The pros and cons of each option should be looked at. P's wishes and feelings have obviously got to be in the balance as well. And again, if a decision can be made that all relevant stakeholders are in agreement with, well, that again should be documented. But then that decision can be made in the individual's best interest and it doesn't need to go to the Court of Protection. Again, it's only if even one of those relevant stakeholders disagrees, the matter needs to go to the Court of Protection. I think of a case where actually I was acting for the father of a young person with quite complex needs. Everyone else, including mother, was in agreement for one course of action. Well, certainly at the beginning, I should say, to change throughout, but at the beginning, everyone was in agreement, apart from my client. Because my client wasn't in agreement, local authority rightly issued proceedings to bring it before the Court of Protection. So it's that's important to be, that's very important to be aware of. Just because an individual turns 18, you as parents still have a say. You are a relevant stakeholder if that individual lacks capacity to make a specific decision. If they've got capacity, then it's entirely up to them, and that's what the law says. But if they lack capacity, whilst parental responsibility and that concept does not exist beyond 18, it doesn't, you are still a relevant stakeholder. The other thing to be aware of is the Court of Protection is only able to consider the available options. So, as I've said in the bullet point above it, the court steps into the shoes of P protected party. So what the court can't do is order a local authority to fund a particular package, because that's not stepping into the shoes of the protected party. Because if the protected party had capacity, then they wouldn't necessarily be able to force the local authority to fund it, or if they were, it wouldn't be through the Court of Protection, as it were. So it's really important to be aware that the court can only look at the available options. So where you're looking at accommodation, and this is generally where I've seen it, and there's a dispute about what the available options are. Well, if the protected party have got their own finances, then we can look at a whole host of various options, because it's not necessarily down to whether or not the local authority funds it. If it's coming down to local authority only setting out what it will fund, then the court can be restricted to those options. That doesn't mean that the local authority can't be challenged for other means, potentially through judicial review and so forth, but not through the Court of Protection. Saying that, I have seen Court of Protection judges give a clear steer to local authorities as to whether local authority should reconsider its decision and so forth. But that's as far as it can go. It doesn't have power to order a particular party to fund something because it's only looking at available options. Now, deputyships. So what is a deputyship order? Well, there's two types of deputyships, as I mentioned previously. One relates to personal welfare and the other relates to property and affairs. It's an order made by the Court of Protection, a deputyship order. So it's only in relation to an individual who lacks capacity. Now, they've obviously got to lack capacity in relation to the issues that the deputyship order has been sought. And what it effectively does is it authorises the deputy, or deputies, can be more than one, to make decisions in relation to that individual going forward. Now, I say deputy or deputies, there's two types as well in terms of where you've got more than one deputy, they can either act jointly or severally. I would always suggest that you look, if you're going more than one, for them to act jointly and severally. What that means is, God forbid, were something to happen to one of the deputies, if they can only act jointly, that deputyship will then fall because they're not able to act jointly anymore. So jointly or severally, where you've got more than one deputy, is always a way to be looking at it. In terms of property and finance, what I would say is really that's only generally necessary where there are decent assets, if I'm honest with you. If an individual's just receiving benefits, then I wouldn't suggest going to the Court of Protection for a property and finance deputyship, because finances in relation to benefits can be dealt with quite simply through an appointeeship through the Department for Work and Pensions. And the reason I say that is because there are costs involved with one, of course, applying for a deputyship, but in terms of property and finance, potential bonds need to be paid into the court and protection fees need to be paid each year. So it's only really where there are sizable assets that it's probably sensible to get a property and affairs deputyship in order to manage an individual's finances and so forth. The court can put restrictions on deputyship orders, and actually one of those that is relatively standard in relation certainly to property and affairs is that a deputy is not permitted to sell the residence where the protected party is living without permission of the court. So the court does still like to put in safeguards for the protected person. The other type of deputyship is personal welfare. Now, in my experience, a number of parents of young people that I've acted for, or young adults that I've acted for, have been really quite keen to apply for this. And that's because they become very worried when a young person becomes 18 and they will have local authorities or GPs or whoever else say, actually, they're an adult now, we're not talking to you, and actually parental responsibility doesn't exist, and all of those things. Firstly, what I would say is, as I mentioned previously, if an individual lacks capacity in relation to a specific decision, you are still a relevant stakeholder. So you still do need to be communicated with, regardless of whether or not there's a deputyship order in place. The court is reluctant to make deputyship orders in relation to personal welfare. And that's because it's seen as really quite a draconian order to make in relation to an individual. The court is far happier making one-off orders as opposed to deputyships for personal welfare. And you can see that in terms of, to make an application for a personal welfare deputyship, you need permission from the court to even make the application. So there's an added step in relation to personal welfare. Where I have successfully obtained deputyships in the past for parents of young people and so forth is where that individual is living with a parent. If they're not living, if they're in a residential setting and so forth, I think it's been very difficult. And arguably would it even be appropriate to have a deputyship where the individual's not living with you. But there's been cases where actually I've shown that the young person or young adult in those cases, one I can think of, required PRN medication, which was effectively given as and when. Now, the GP had prescribed it, but had said to the parents, you know this young person the best, you decide as and when it's given. And that was an argument that we made to the Court of Protection, that actually we can't run a seek a one-off order every time PRN needs to be administered, because we don't know when it's going to be administered. It's as and when. But the GP is clearly supporting us in terms of giving us that authority. We just need authority from you, court. Whether or not the court would agree that now, I don't know, because that was a couple of years back. But I just flag with you that they are not easy to get, personal welfare deputyships, and I think it's important to say that before parents or anyone looking for a deputyship spends what can be significant sums of money applying where prospects may not be that strong. So that's deputyships. The other option is lasting power of attorney. Now, important, huge difference. A deputyship order is from the Court of Protection, so that's where an individual lacks capacity to make a decision. Lasting power of attorney is made by the individual, and therefore they must have capacity at the time they make it. Okay, it's essential they have capacity at the time they make the lasting power of attorney. And if an individual has capacity, then they can make a lasting power of attorney. And there are two types again. There's one in relation to personal welfare decisions, and the other in relation to property and affairs. Now, in terms of lasting power of attorney, I can appoint one attorney or more than one, and again, I can appoint them jointly or severally. I would say always look at joint and several for the attorney, so that, again, God forbid, if anything would happen to one attorney, the LPA wouldn't fall, because the other existing attorney can act severally as opposed to having to act jointly all the time. Interesting difference is in terms of personal welfare, that lasting power of attorney only kicks in where an individual loses capacity. So I make my lasting power of attorney when I have capacity, and what I'm saying is, in the event I lose capacity, these attorneys, I want to make these specific decisions, and you can be quite clear as to the decisions you want them to make. You can also be clear as to you want some decisions has to be made jointly if you want them to be, as opposed to joint and several on everything. So you can tailor the lasting power of attorney however you want it. In relation to property and affairs, I can make a lasting power of attorney and say, yes, in the event I lose capacity, this is the individual or individuals I want to make decisions about my finances for me on my behalf. Or I can say, were I to lose capacity, these are the individuals. However, I also want to give them authority now to work with me in relation to my property and affairs. So there's a distinct difference there. What I would say in terms of lasting powers of attorney and what I've seen in the past is they're relatively easy to register. Right? Last I've seen them, they can actually be done online now. Now, you do need a certificate provider to effectively confirm that the individual has capacity at the time of making lasting power of attorney. I haven't done these in a while now, but certainly when I was doing lasting powers of attorney, I would always do a contemporaneous note of my conversations and so forth with the individual, and that would go on file. And the reason I would do that is because if they were ever challenged later down the line, that could be 2, 3, 4, 5 years, whatever, I had those notes on file to prove, as evidence of when the individual made lasting power of attorney, they had capacity, and here's the evidence of it. Because I've seen too many cases where young people turn 18 and they make lasting powers of attorney, and it seems quite often they've had quite a bit of help from parents and so forth. And the question then becomes, well, actually, did they have capacity to even make the lasting power of attorney? Because if they didn't have capacity to make the lasting power of attorney at the time they made it, then it's null and void. And then you get in disputes in terms of the court of protection in relation to the LPA being null and void, and then inevitably there's follow-on disputes as to decisions that need to be made and so forth. So I just flag that in terms of whoever's effectively your certificate provider signing off to say, yes, the individual making the lasting power of attorney has capacity, make sure they do it correctly. Make sure they do it correctly. Now, the last thing I really want to talk about, and actually, if I've got a bit of time, I might jump back and mention deprivation of liberty because I'm aware that I haven't covered that. But the last main slide I've got here really is talking about capacity in the context of a SEND tribunal. And the reason I've specifically done a slide on that is because it's interesting in the SEND tribunal in that there's some anomalies that don't really apply in any other jurisdiction. So, important to be aware that in general terms, it's a parent's right of appeal to the SEND tribunal. That is up until an individual turns 16. Where an individual turns 16, the right of appeal, and this is set out in the Children and Families Act, the right of appeal then reverts to the young person. So the parent no longer has a right of appeal, it is the young person who has the right of appeal to the SEND tribunal. However, this is based on that assumption, remember the assumptions in the guiding principles in the Mental Capacity Act in terms of assuming capacity. That is based on the assumption that the young person has what's called litigation capacity. If the young person does not have litigation capacity, then the right of appeal reverts back to either a deputy if there is one, an LPA if there's one. If there's neither of those, it reverts back to the parent as what's called an alternative person. Now, it's important. The reason I flag this is I was involved in a case last year, maybe 18 months ago now, called and Greenwich. I can say it because it's a reported case, so I'm not divulging any information that's confidential. That was a case that went to the upper tribunal. It was a case I wasn't involved in at first instance. Parents came to me and asked for my views on an appeal and so forth. And one of those issues was that at first instance, no one had grappled with the issue of capacity. And what we said in the upper tribunal is, well, it should have been. It really should have been. And the tribunal needed to look at it. And in that case, at first instance, the parents were represented by a different solicitor. So the argument we ran in the upper tribunal was, well, they might have been represented by a solicitor, but that does not absolve the tribunal of its responsibility to grapple with and determine the issue of capacity and litigation capacity in particular. And the tribunal unfortunately sided with us on that. So I raise it because it is an issue. And it's somewhat one to be very aware of, because actually litigation capacity is quite a high threshold in terms of all the relevant information that an individual needs to be able to understand to then retain long enough to weigh up and then provide decisions back to me. So effectively to be able to give me instructions. And tribunal proceedings can be complicated with expert evidence and working documents and tactical negotiations and all of those things. So whilst some would say it's positive that we're giving 16-year-olds the right of appeal, and actually that reinforces the UN Convention on the Rights of a Child, others will say, well, it's a little at odds with the rest of our legal system where, in general, a 16-year-old can't bring proceedings by themselves until they're 18, and generally they will require a litigation friend. So I raise that just to be aware of. Pardon me, sorry. Now, because I've got a little bit of time, it's probably worth, and I haven't done slides on this, so I'm going to talk slightly off the hoof, but talk about deprivation of liberty, because I've realised that I haven't touched on that. Now, we looked at the beginning in terms of sources of mental capacity law, and you saw at the very top there was the European Convention on Human Rights and Fundamental Freedoms. And one of those is liberty. Fundamental freedom is liberty. There are certain cases where we can lawfully deprive people of their liberty. So, for example, those that are subject to a custodial sentence, that is authorised via the criminal justice system and the criminal law. Those that are detained under the Mental Health Act, again, that is authorised under the Mental Health Act. But there is another key category of individuals who can be deprived of their liberty, and that's those who lack capacity. And where we are going to deprive an individual of their liberty and they lack capacity, and we're not under the criminal justice system and we're not under the mental health legislation, then the Mental Capacity Act kicks in, because we can only and should only be depriving those individuals of their liberty if it is in their best interests. So again, in terms of the key principles. And when we're looking at, and again, another core principle, least restrictive option, I think I mentioned this at the beginning. Now, where you've got an individual that's 18 and over, you have the possibility of what's called a standard authorisation. They're quite affectionately known as DOLS, DOLS, deprivation of liberty safeguards. They are in very specific circumstances, and it's generally where an individual's over the age of 18, they're under constant control and supervision, because that's the current test for deprivation of liberty. We are waiting to hear what the Supreme Court's going to say on it, but as of today, that is the relevant test. They're under constant control and supervision. They've been deprived of their liberty. If they're in a hospital or registered care home, then the relevant public body, which will be the local authority or the ICB, can put in place a standard authorisation. Now, that then makes the deprivation of liberty lawful, but what it also does is it adds in very particular safeguards. So it means that what's called an RPR, relevant person's representative, needs to be appointed, and that relevant person's representative can challenge that standard authorisation in the Court of Protection. And one very useful thing to be aware of is that legal aid for the relevant person's representative or the individual is non-means tested. So they don't look at your finances where you're challenging a standard authorisation. Where we're not looking at a standard authorisation and an individual's liberty's been deprived, and actually that includes 16 plus, so 16 to 18, there can't be a standard authorisation in place, but can still have their there can still be a deprivation of liberty. The court has said you can't use parental responsibility to authorise that. So there does need to be court authorisation of that deprivation of liberty. Now, in that case, the public body should be applying to the court for authorisation. If all parties are in agreement and the court is satisfied with the paperwork, then it can authorise it on the papers. However, if one stakeholder is not in agreement, then the court won't authorise it on the papers. It will call it in for a hearing and it will probably be asking for additional evidence, make directions and all of those things. Now, that's also relevant post 18 if we're in the community, for example, because bear in mind those standard authorisations only apply to care homes and hospitals. So if we're in the community, because you can have your liberty deprived within your own home, again, court authorisation is required from the Court of Protection. Again, it will be looking at best interests, and again, it will be looking at least restrictive options. So I thought, because I had a little bit of time at the end, it may well be worth just raising that. I don't know if it's relevant to anyone here or not, but I thought I'd just mention it. Now, if I'm not wrong, and I click, I'm going to ask if there's any questions.
Brilliant. Thank you, Kevin. What an interesting presentation. Does anyone have any questions regarding their own situation? I'm just going to stop recording